Welcome, everybody, to our industry update this month. I'm Jill Cox with Chicago Title. I wanted to start by giving a big thank you to everyone who registered and said that they had an upcoming listing that they would be willing to close through Chicago. That is how your Chicago Title sales reps get paid. We get paid through closings just like you guys do. So thank you so much for your support. Your rep will be reaching out to you soon. And I wanted to do just a quick touch on AI. I know a lot of you have been hearing a lot of buzz about, of course, Zillow's integration with ChatGPT, and then also bio optimizations and listing description optimizations, things like that. No one has sat down with you yet to explain exactly what that means. Reach out to your Chicago Title rep. We are all trained and have studied a lot on what this means for brokers, and we can sit down with you and help you optimize your bio so that when people are searching for you using AI, which 82% of people are now using platforms like ChatGPT to do searches, we will make sure that they find you. And same thing for your listings. They're now using ChatGPT to look for listings. So we need to optimize your listing descriptions and help people find your listings. So reach out to your Chicago rep and we'll be happy to help with that. And with that, I'm going to turn everything over to Damian and Scott. So if you hadn't heard, these two incredible real estate attorneys have joined forces and are now the proud owners of Cox Peterson LLC. Started their own law firm together this week, so we're very excited for that. And we are looking forward to other updates today, and we're so glad that you all joined us. So thank you so much. And Damian and Scott, feel free to take it away.
Thank you, Jill. Damian, Wonder Twin Powers activate.
I don't know where you are on your screen, but I'm bumping. That makes you feel better.
Some of our more senior folks like you will remember that cartoon from many decades ago.
Like me, you're the older, more seasoned attorney in our law firm, my friend. I have news for you.
All right.
I may have the first billing on the name, but Peterson Cox sounded really bad. So,
well, should I tell them about our operating agreement clause?
Sure, I think you should. Yes.
We have in our operating agreement, we have a literal paragraph that says that it's going to be Cox Peterson unless we find a partner by the name of Long. And then we've agreed that we will reshift the name to Peterson Long Cox. And then it sounds, I think, much better than it currently does. So yikes.
Yeah.
Yikes. Hey, I didn't give you your last name. I'm just playing with what I've got here. But in all seriousness, it's a little change this week. It really, in terms of what our car members might see, and I know we've got so many of you guys on here, I'm sure, as well as other non-realtor members probably participating as well. But from a car perspective, car has become our Cox Peterson law firm's client, and so most of the stuff that you've seen me do, you're going to continue to see me do, and you'll just probably, in some cases, get a little bit bigger splash of Damian involved with stuff. And both in the background and in the foreground, Damian's been really involved, almost on a voluntary basis for a lot of years that we've had a chance to work together. And as I think most people that know either one of us know, we've become good friends. And there was a good opportunity to kind of have a win-win for Carr and for, I think, the two of us, and look forward to being able to work with some different clients and to diversify a practice a little bit and have some fun doing it. So we'll see how it goes.
So with that, what do you want to talk about? Nobody really cares about us. You know that, right?
I know. Well, all right. So then you decide. Nobody cares about us. We've got. Well, how did you say Jill build this? What do they want to hear about, Jill? They want to hear about the forms. A little bit. They want to hear about an industry or regulatory maybe update. We can talk about all that stuff.
I think that sounds great. Yeah, I think everybody's eager to get a little snippet of what's going on with forms and what those major changes are going to be come January. And then, there are some new things happening with the division, it sounds like. So definitely worth talking about.
Yeah, an exciting time for sure. I don't know, Damien, what should we start with? You want to talk a little bit about kind of the rulemaking process that's coming up? So anybody who's a car member would have received within probably the last half hour an email from the Colorado Association of Realtors that talks a little bit about what is at this point proposed Commission Rule 6.27. It's proposed. Now it's already been included in a real estate commission position statement that was already adopted, position statement 31, back in early October.
October 7th.
October 7th. So the position statement that refers to the rules in place, the rule itself hasn't been put into place yet. So that will be considered and heard by the commissioners at the December 2nd meeting. And anybody on this call who's a licensee would have received from the Division of Real Estate directly within the last couple of weeks at least one, if not maybe a couple of notices related to a stakeholder event that they're having on November 19th. So here in, what's that, about 2 weeks out, to take stakeholder feedback related to the rule. And so Carr has had some impressions on the implications of the rule. And you would have seen, like I say, from the Realtor Association just within about the last hour, kind of an update expressing some of our concerns related to the proposed rule that's being considered on December 2nd and a stakeholder meeting on November 19th with information, some registration links, a link to the actual rules that are being considered. And there's a variety of things, but I think one of particular note, and I don't know, Damian, why don't you go ahead and explain maybe the gist of 627 and how it interrelates with the position statement?
Well, I'll do that. I mean, I guess what I'm going to start with is that this interplay comes also on the heels as far as forms updates, guys. I'll tell you there's what is it, 27 forms or something like that changed this year. I will say that a lot of it is the division has taken a new approach to the forms committee, and so I think there's somebody else that is now drafting the forms, and they're trying to, I think, put their language in there. I think they think it cleans it up and makes it more consumer friendly. I don't know I drafted them before, so I'm not sure if I agree or not, but nonetheless, there is a lot of substantive or not substantive changes like that. There are a lot of substantive changes in the forms that have to do with statute changes and things like that. But the biggest one that really has to interplay with this Rule 6.27 and the Commission Position 31 has to do with the removal of what's called paragraph 5.3 of the listing contracts. For those of you that haven't been seeing this, like Scott and I have been living and breathing it every day for months now. 5.3 is in the listing contracts, is the permission that the client gives to a broker to share confidential information with their supervising or employing broker. And this is something that's been culminating over the last year and a half, 2 years of consternation, honestly, between the industry as well as the division, trying to figure out what needs to be in here. And frankly, what came out of October's meeting was not only the repeal of 5.3, which now means that there is no permission for a designated broker to share confidential information with their employing or supervising broker effective January 1st of 2026. But what the commission heard was proposed rules and commission position statements that Scott alluded to that is then supposed to clarify what needs to happen in order to share that information. And 6.27 is the big one on that. And it's a new rule that hasn't been approved yet, which, Scott kind of said, it's a little weird to have a position statement that is explaining a rule that hasn't been passed yet. So that I don't quite understand how that happened, but nonetheless, that is what happened. But 6.27 goes through and now talks about informed consent. And it says essentially that in order for a broker associate to share confidential information with their supervising or employing broker, they're going to have informed consent from the client. And I think a lot of us that saw this was going to pass and stuff were hoping that the rule would have some more body to it or something to it that would kind of explain what exactly the Attorney General's office and the division were worried about when it comes to the sharing of confidential information to employing or supervising brokers. But it didn't really go as far as I guess I was expecting. So what the rule essentially says is and this is proposed, so hopefully they're going to update this or do something once they get stakeholder input. But what it says essentially is this: a broker representing a buyer, seller, landlord, or tenant, or acting as a transaction broker must obtain the informed consent of a client before disclosing any of the client's confidential information for any purpose. The client's informed consent must be in writing, and it must be voluntary, specific, and made following the broker's full disclosure of the risks involved and the alternative options available. So that's what they're saying is now the informed consent that brokers are going to need in order to give to their employing broker, or in order to give confidential information to their employing brokers. I think our concern, and Scott can speak to this a little bit, our concern has all along been, is this good for consumers? Is this really what, if you can't give your confidential information to your broker, your employing broker, to get advice on how to deal with something that you've never seen before, how is that really helping the consumer? So this is what's coming. I think it's probably going to pass because they did pass Commission Position 31, which we can go into. Do you want me just to kind of talk about that too, Scott, or do you have anything to add before I get into it?
No, I mean, I think, yeah, you've expressed the concerns. I can't share. Do you have the CP 31 up or available to share on the screen?
Hey, Damian, I can't hear you.
Can you make me a co-host so I can share?
Don't let your internet go out again, Damian.
Geez, I hope not.
Okay.
I see questions coming in about what was the argument to remove 5.3. And what it comes down to is that this belief that the statute that has been around for 30 years requires this informed consent, and apparently 5.3 didn't go far enough. That's what I've gleaned from the commission hearings that we've seen, is that the division and the AGs don't think it goes far enough. I'm not sure why it had to come out of the listing contracts and why it couldn't have been beefed up in the listing contracts, but that's kind of what we're getting from this. And some of it is a little elusive as far as what the rationale is, but that's what we've been hearing in the hearings. Am I a person now? Oh, I am a person. Okay.
You're a sharer.
So
Yeah,
I'm a sharer now.
5.3, just so everybody knows, I'll just read it from the listing agreement. And it's the same across all 4 listing agreements. I'm just reading from the buyer one, but buyer consents to broker's disclosure of buyer's confidential information to the supervising broker or designee for the purpose of proper supervision, provided such supervising broker or designee does not further disclose such information without the consent of buyer or use such information to the detriment of the buyer. And that's just the buyer one. So the seller would say seller, landlord would say landlord, and tenant would say tenant. That's the provision that's coming out. And it's being replaced with this now expectation in 6.27 that's going to be that in lieu of that being consent sufficient from the listing contract, that there's some additional informed consent. And this is what now is this position statement 31 that's describing what informed consent might be or what it's going to look like. Now, I think it's been made abundantly clear in all of the public sessions, at least, that the division, or the commission, I should say, does not have any intention whatsoever of actually promulgating a document, a commission-approved form that might satisfy informed consent, and so that's concerning. What it does say, if you look in that first paragraph, when an employing broker is, wait, where am I looking here? Where's the specific voluntary?
That's in the rule. So here's
that's
the
in the
rule.
rule. There we go.
Yeah. I'll blow that up so that old people can see it, Scott.
Yeah, so I don't have to lean in and squint. A broker representing a buyer, seller, landlord, or tenant, or acting as a transaction broker must obtain informed consent of client before disclosing any of the client's confidential information for any purpose. The client's informed consent must be in writing. It must be voluntary, specific, and made following the broker's full disclosure of the risks involved and the alternative options available. So that's what your document, when you guys go to create this on your own behalf, because there's no, I don't think, commission approved form coming, it's going to have to make sure it checks all of those boxes. In writing, that's easy. Voluntary, specific, and made following presumably your full disclosure to the consumer of any risks involved of providing or allowing you to share that information, and any alternative options that you might have available to you. So Damian, what do you think? Well, voluntary, I think, writing is probably sufficient. Voluntary means you're not, pinning their arms, behind their back and forcing them to sign with their teeth or something. Specific, what do you think specific means, Damian?
Yeah, I'm not entirely sure. I mean, I guess so if you look at this informed consent, I'm going to roll down, and these are all the same for the different types of relationships that you have with consumers. But this is what confidential information is. It's coming straight out of statute of 1210-4042, 1210-4052, and 1210-4073. This is transaction broker. This is essentially buyer agent or tenant agent, and seller agent, landlord agent. And you can see it talks about, and I think the best one to focus on is motivating factors, because to me, that is the one that kind of reaches across. You have something that's screwed up on a deal and you're trying to figure out what to do with it. That's when you want to go talk to your employing broker, but it's impossible to know what to do with it if you don't know what your motivating factors are of your client. Does your client want to stay in the deal? Do they want to get out of the deal? Do they want a better price? Do they want to negotiate credits? Do they want to negotiate some kind of extension of the closing? Without knowing the motivating factors, it's just almost impossible to really know how that goes together. So that one, I mean, there's others in here, obviously, but this one seems to be the overarching one that I think is problematic when we start talking about supervision that you need, and I can't seem to highlight it. But what is also concerning about the fact that the division is not creating a form, which they did make that clear in that last meeting that they weren't going to, is that they also said that everybody else can make their own form, which is fine, but they said if you don't do it well, then you're subject to discipline because you didn't meet the requirements of the new rule that they passed that tells you how to do informed consent. So I'm like I said, this is still a proposed rule. It's not in its final form. There's an opportunity November 19th for stakeholders to give input as far as what they like or don't like about it. There's also going to be opportunity before December. You can turn in written comments before November 21st, and you can also testify at the hearing on December 2nd. After all of that, then they will come up with the final form that may or may not be anything like what we're looking at today. So keep that in mind. But going into the position statement, I guess we can go through the rest.
Let's talk just very quickly about the motivating, like, you're pointing to motivating factors, and I think that's probably the easiest one to talk about. Some of these other ones might be a little bit more difficult to wrap your head around, but so I'm a seller, Damian, and I've got a new home under construction that I got to close on. I got to have the money to close on in 3 months. And I've set up with my listing broker that I need to sell this property. I need to be fully funded and ready to close on my next property within 3 months. Earnest money is non-refundable over there. I've got to close. And I'm getting into, I don't know, 8 weeks kind of left before that deadline. And I'm a broker associate now, and my seller client hasn't authorized me to share any of their confidential information. But they're asking me for some, and I'm a new broker, and my sellers asking me for some strategies, or what can we do possibly to help move this along? And if I don't have that informed consent, would I be able to go to my employing or supervising broker and ask them if they have any strategies to help me move the property along? I've just been in the business for 18 months, 12 months, maybe 3 years, whatever it is. Haven't dealt with this kind of pressure before. And could I go to my employing broker and have a conversation with them to help see if they can help me with some strategies?
Yeah, I mean, to me, that's the problem. I don't think you can, right? I mean, that's the way it looks to me, is that if you're starting to disclose motivating factors about, hey, my client wants to get this place to figure out and wants to know how we negotiate for it, you're going to have some kind of signed informed consent that meets this requirement, whatever 6.27 final adopted form is in. It's going to have to meet that. So
let me ask you this. This is I'm a broker associate of yours. You're my employing broker, and you own the brokerage firm, and your brokerage firm is party to this contract, this listing agreement that I have. That I have. I'm signing it on your behalf because I'm authorized to do so. And in this listing agreement with my seller, they want to start off at a higher price, a little bit higher price than what I really want to list it at. But I say, well, that's fine. But in our listing agreement, what I'd like to do, seller, or what I think makes sense for you to do is, let's say for the first 30 days of this listing, in the additional provisions of our listing agreement, we're going to say that we're going to list your property at $950,000. And if in 30 days we don't have a contract on it, then we'll automatically reduce the list price by $25,000, move it down to, down by $25,000 automatically. Totally common situation that I might find myself in as a listing broker.
Yeah, price reductions, absolutely.
Correct. So I've signed this contract on your behalf as you as the broker owner, brokerage firm, supervising broker, whatever. You have a responsibility, Damian, to maintain that listing contract in your file. But that listing contract now contains, motivating factors, or maybe that falls under A, which is the seller is willing to potentially accept less than the asking price of the property.
Yeah, exactly. I mean, it's definitely a problem.
How do I share my listing agreement with with the broker to whom their brokerage firm is a party? How would I do that?
Well,
is there any recommendations?
Well, thank you for setting me up for commission position 31, Scott. I really appreciate that.
I know it was intentional.
So this is commission position 31. And again, this was passed. This has already been approved. This is essentially guidance. Now, keep in mind, position statements are guidance. They are not the law. You cannot violate a position statement. But a position statement is supposed to give you kind of an idea as to what you have to do in order to comply with the law. And that's what's weird about this, is because you'll see here in this position statement, as we get down here, it talks about conflicts of interest. Oh, and it says right here, it says Commission Rule 6.27 sets forth requirements for informed consent, which is not even passed yet. So even though this commission position statement is passed, the rule that it's talking about has not passed. So that's odd, is all I'm going to say. But I want to talk about
before the horse.
Yeah, a little bit of the cart before the horse. That's a good analogy, and works for me being
you're a horse guy.
A horse guy. So, but this is really where I think it's interesting as to what the division and the attorney general are coming up with as far as instructions. So let's say you can't get informed consent, like Scott's talking about. Let's say that you just got done telling the consumer, oh my gosh, hey, let me tell you about wire fraud and, and personal identifying information, and tell you about all the things you need to do on inspection and all these warnings and everything else. And then turn around and say, by the way, can you sign a document allowing me to release your confidential information to my employing broker? You can see where somebody might be like, I don't know if I want to sign that. But this says, without informed consent to the client, potential solutions available to the employing broker include the following. And so the first one, I love this. The employing broker can designate themselves or another experienced and competent broker to be a designated broker in the existing transaction. So you have a consumer. So let's say that Jill's the consumer. She goes to Scott, and Scott says, hey, I'd like to get informed consent. She says, no, I don't want Damian knowing anything about what I'm doing, which sounds like our marriage. But nonetheless, she says, no, I don't want him knowing anything about it. And so Scott says, I'm sorry, Damian, I can't give you any confidential information to help me with Jill because, she doesn't want me to sign an informed consent. Then I say, I can unilaterally, as the employing broker, can say, well, that's tough. I just designated myself as the employing broker. Tell me everything, Scott. Isn't that the weirdest?
You won't give me your informed consent, but I'm going to take it
I'm going to take
myself, which I have a right to do as a designated broker.
Under the statutes, the employing broker designates who the designated broker is. So apparently what they're saying is if you can't get informed consent from the client willingly, you can just take it by designating yourself, which
it's a good solution.
I'm not sure how that works. But I like this other one too, which goes to your question about the listing contracts. The employing broker can direct their brokers through training and the office policy manual to not include confidential information in listing contracts or to redact that information prior to providing listing contracts for review. So your contract, Scott, you can just go through and redact out all the provisions that you think are confidential. And then me as the owner of the listing contract cannot see the entire contract.
The principal party to the listing contract. You're a party to yes, you're an owner of it, but you're a party to it. And you don't know what the contract says because the broker associate who's merely executed on behalf of the brokerage firm has redacted information from that contract. But you're responsible. Yeah. You have civil liability, you have regulatory liability for oversight of the terms of that contract.
Vicarious liability for anything
Vicarious
that you do,
liability.
even though I can't know what the hell's going on between you and Jill.
Well, you shouldn't know that anyhow, Damian. I'm
I
just,
mean, yeah, I think this is, I mean, I'm like, really? So what if I'm saying, like, what if Scott dies? Like, we have this deal he does with Jill, close out the transaction. I have this redacted listing contract in my file, which I'm not sure, it doesn't say anything about getting a new one later after the closes or anything else or anything along those lines. So I'm like, so Scott dies and then I get sued based on what happened in the transaction. And I, when I'm providing in discovery in the civil action, I'm going to give a redacted contract and the judge is going to say, well, why can't they have the full one? Or during discovery, and the attorney's going to say, well, why can't we have the full one? I'm going, I don't have it. Scott's gone. He redacted it. It's crazy.
you weren't allowed to have it. The judge is going to say you should have designated yourself as a broker. You should have forced informed consent on the consumer by merely
I
designating
guess.
yourself.
Um,
The next one's
this one,
even good, even better.
yeah, this one's also fun. So adopt a policy to refer a client to another broker or brokerage firm or an attorney if the transaction or the client's circumstances are so complex that the designated broker is unable to perform the required brokerage duties and the client refuses to provide informed consent to allow the employing broker to assist. So can't get the employing broker to assist. Designated broker, you just have to refer out the business.
Well, or better yet, consumer, you need to go now engage an attorney to manage me or to direct me because I'm not capable of not receiving supervision.
Yeah, because I can't get advice from my client, so you're going to have to go hire a lawyer. And the other thing that's crazy about this is that it's not like the listing contracts have anything in there that says that you can terminate it based on some kind of conflict of interest or whatever the hell this is. I mean, so you're going to unilaterally terminate a listing contract with the client because this position statement says that you have to somehow not refer out business. I'm sorry, Jill. We're going to have to terminate your listing contract because we have to refer out the business because you didn't sign the informed consent, and Scott isn't capable of handling whatever situation you have going on here. And I could handle it, but I can't. But I can't advise him. It's crazy. So
Well, those are
yeah,
your options at least.
what's that?
Those are the options at least.
Yeah, and those are the only three they came up with.
You can
Which
force informed consent on the consumer.
Yeah.
You can refer the deal to an attorney or to another brokerage firm,
assuming the client is willing to terminate your agreement.
or you can redact the critical information.
Yeah, and not all of those work in every single situation either. So it's wow.
Well, there's been, just piles and piles of problems historically with regard to this specific issue. I mean, the statute's been the same exact language for the last 30 years. And clearly there's been all kinds of repeat trouble with employing or supervising brokers misusing this information. That must be the case, right?
Yeah, I mean, you and I obviously you're being tongue in cheek, but um I don't know. I'm assuming that there was some issues, and I heard some things in the hearings that lead me to believe that there have been issues at the division. So I don't want to completely discount the concern, but it sounds like the problem was with an employing broker. Like if you gave me all of Jill's confidential information under your listing contract so I could advise you, I was turning around and using it to Jill's detriment with my client, which seems like there's a lot of other ways to get there to punish an employing or supervising broker that breaches that trust of supervision by doing that. So I would have thought there was, well, you and I have obviously had conversations about
Well, sure. I mean,
and recommendations to the division about different ways of doing this, but it seems like this is what they're set on.
to the extent that the employing broker is misusing that information, they would have been in violation of clear language in 5.3 to begin with. So the brokerage firm would have been in breach of contract, breach of their uniform duties under 5.3. And I don't know, there's a half dozen different commission rules or license laws that I would think the regulator could and should revoke the license of the employing broker or supervising broker that's misusing it, suspend them for years, downgrade their license, whatever. I mean, there's all kinds of angles to discipline an inappropriately used confidential information by a supervisor or employing broker. Instead, this is going about it in the opposite direction. And so 6.27, as it's written, it's not even the employing broker. Well, although I think the employing broker could have trouble, but it's the person who's violating the rule would be the designated broker if they're sharing the information. In other words, they're the ones that get in trouble for a 6.27 violation because they're the ones sharing that information.
And probably in the interest of trying to get supervision to figure out how to handle something that they've never come across before, which is just strange to me because you would think that the consumer would want that, but maybe the informed consent won't be that hard to sign. It's just weird that it's got to be outside of the listing contract, and now it's going to be a form that's not promulgated by the real estate commission, that's going to be, subject to review by investigators in any complaint as to whether or not it meets whatever standard this is in 6.27. That's just weird.
That's correct. But the flip side of that as well, the rule is designed to prevent the designated broker from sharing the information. In kind of thinking about this, I think they could also loop in the employing broker, because if they're supervising or they have supervisorial responsibility over a designated broker who doesn't understand the rule or doesn't adhere to the rule, I think the division could also regulate and take disciplinary action against the employing broker for not appropriately supervising their designated broker who violated Rule 6.27 to begin with, right? I mean,
I hadn't thought of that.
It's like
I hadn't thought of that.
But I mean, am I wrong in thinking about it like that? Like that's
I don't know. I mean, I don't know. I mean, I would hope not, but you're right. I mean, I think technically seems like it. So I don't know. I will say this is what creates problems with the number one of forcing the employing broker as the designated broker, is that they changed position 22. And this is also the updated for 6.17, which is again proposed. And here's 6.17 is here. These are the things they're proposing, which I think is important to look at. It says that the employing broker supervises the designated brokers that represent both sides of the same transaction, and confidential information about one or more of the clients will be shared with the employing broker. The designated brokers must disclose this as a conflict of interest to their clients. The designated broker must include a statement about the conflict of interest and supervision in the informed written consent request for their clients. So now if you have a brokerage firm that is double ending deals, which happens quite a bit, the designated brokers are the ones that are responsible for making sure that they disclose this new conflict of interest, which is interesting because it literally was in the position statement 22 before that was not a conflict of interest. But E is also something that I get what they were talking about here, and this to some degree makes some sense. It just gets really complicated for small brokerage firms. If you're like one or two associates in an employing broker, it says if the employing broker supervises the designated broker that represents the opposite side of the transaction, and the employing broker represents the other side of the same transaction, the employing broker is prohibited from receiving confidential information about the designated broker's client. So now that means you have to redact if you have a listing contract that has confidential information in it. And I keep seeing flip ups. There's lots of chat going on here. Scott, have you seen all the flip? But
I'm afraid to look.
Yeah, me too. But confidential information is that stuff that's specifically in statute, motivating factors. They would pay less or take less or pay more, etc. But this essentially says that the employing broker now is prohibited from receiving it. So you couldn't designate themselves to be a designated broker if they're on the opposite side of it.
You couldn't force informed consent. Option one would be you can't force informed consent by designating yourself to be a designated broker. So you'd be left with either refer, make the consumer hire an attorney, or
I think that's it, because redacting doesn't get you any supervision.
Oh, that's true. Yeah.
Yeah. So, the redacting is only for delivering your files to the employing broker. It doesn't do anything for you for getting actual advice on how to help your client.
Yeah.
A couple people have asked if you could add your employing brokers, the co-listing agent or co-buyer's agent.
Joe, say that again. You do. Somebody had pointed out. Sounds like you've got some distortion maybe in your microphone. So just say that one more time.
Oh, okay.
Yeah, there's an echo or something, honey. I don't know if you got the right, if your mic is set up right. Mine keeps trying to change to my system's default.
I mean, you can hear it. Just it's a little hard to hear. So go ahead and say it again.
A couple people were asking if you could make your broker co-listing agent, for example, and tie them in that way.
Yeah, that would be the designating them the employing or supervising broker. You designate them as a co-broker essentially on the transaction. They would become an additionally designated broker, which means that would establish the brokerage relationship with the buyer or seller, and therefore, they wouldn't be a third party to the agreement who would be not able to receive informed consent. But again, I mean, to Damian's point, the irony of that is that it's essentially like it's forced informed consent. It's forced consent, which those two words don't seem to go together to me, but that would be the effect of that. I think legally you could. There's nothing that would preclude that.
Yeah, it says you can. It literally says you can in this position statement that, naming your employing or a supervising broker as a designated broker on it means that they can now receive confidential information if you were unable to get the client's voluntary, specific, informed consent.
Yeah. Again, you're not going to give me your consent. I'm going to take your consent.
It's so weird.
Is this better? Can you guys hear me now?
Oh, night and day.
Yeah.
Perfect.
Oh my gosh. Okay. I think I had a loose cable on my microphone. Let's see. So, oh shoot, now I lost it. If you guys could put your questions in Q&A, that actually would be a lot easier for me to manage than the chat, just because the chat's gotten really, really long, and I want to make sure we try to get to as many questions as we can. Let's see here. Could you add this language to give permission in additional provisions?
I think you could. I mean, remember. So people have said like, oh, could we just reinsert 5.3? And clearly that would not be appropriate if the divisions and the AGs and the commissioner's perspective is that 5.3 is currently insufficient to meet the statutory requirements, then just merely reinserting that is not enough. So I think you could certainly add language related to informed consent to the additional provisions. It would just have to meet the standard, which that's in the rule, but the specific and voluntary, and you have to advise related to the risk and benefits.
They're clearly saying that 5.3 didn't meet this standard already. I mean, that's clear. What the interpretation is that 5.3 just didn't go far enough. So if you are to insert language in, you're going to have to, as Scott said, voluntary, specific, and made with the following broker's full disclosure of the risks involved and alternative options available, plus apparently this disclosure if the broker is on the other side, which is, again, whatever. So,
let's just
do some work
for a second. I mean, let's do. So voluntary, in writing, easy. Voluntary, specific. I think the specific refers to, what information, what specific information, confidential information. Again, and it's the same essentially the same under all three of the statutes. What specific information somebody is willing or able to share. Now scroll back up to the and made following the broker's full disclosure of the risks involved, and so that would be. I guess the risk involved, or at least the perceived risk, I think, is, hey, my employing broker may take this information and somehow use it against you, consumer.
I think you'd almost have to say, even though prohibited from doing so, the risk is that by giving this to them, that it could be inappropriately used, right? I mean, would that be the risk, I assume?
Sure. And I suppose the risk involved with not providing or not receiving the informed consent would be, I'm not able to obtain supervision, to a level that meets my experience. And, I guess it'd be both sides of the risk would be need to be disclosed. I mean, this is to answer, I'm going back to the question, which is, can this go in the additional provisions? So the clause is going to be pretty expansive in the additional provisions that speaks to the risk. And then also the last part is to what are the alternative options available? And I guess you could use the position statement to some degree for that. You could say your other options, buyer, seller, whoever, would be to these three options. We could either,
We can force consent.
we can force your consent. We're going to take that consent. No matter what you say, we're taking it.
And by the way, guys, I saw a question that says, does the client have to agree to it? No, they don't. The employing broker actually is the one that designates who can work on a contract, or who is the one that is the designated broker within each of these listing contracts. And most of the office policy manuals or the policies of the brokerage firms is that, hey, if you acquire a client or you source a client, then we designate you to work with them. But employing brokers have the ability under the statutes to unilaterally decide, you know what, Scott, I'm tired of you. We're going to fire you. And Jill, I'm sorry, but I'm designating myself to take over your listing contract.
Yeah, I mean it's the same discussion, that's very common in a situation when a broker associate leaves a brokerage firm, goes to another brokerage firm. It's not the broker associate's decision, like where that goes. It's the employing broker, the brokerage firm, the original brokerage firm's decision. And if they want to, they certainly have every ability to say, hey, you want to move along, but we're going to redesignate, ourselves or another broker in the existing brokerage firm to take over this business. And that's a unilateral designation. I mean, literally, number one is taking consent. It's literally seizing consent from somebody who doesn't want to otherwise give it to you. And so then to just close kind of what we were talking about, this additional provision that you're going to be putting together would be then that the first option, we're going to take your consent if you don't want to give it to us. Two would be we can redact this information from the listing agreement, or we won't put it in the listing agreement. I don't know, where would you put that agreement on another side agreement or something that then you couldn't provide? I'm not even sure what the alternative for not putting it.
I guess you'd print it out, you'd use a magic marker and redact it out, scan it in, send it to the employing broker so that you could keep yours. But then there's all sorts of questions about, the software programs and what do they provide and what access does the employing broker have to those programs and that stuff. I mean, it's fun.
So not included in the listing contract, or to redact that information prior to providing. So that would be another option that a consumer might have available to them. And then the third thing that I think would need to be addressed in terms of the other options available would be, well, you can go hire an attorney, buyer, seller, landlord, tenant, to take care of the supervision. Or we could refer you, even though we're just getting into our relationship. Let us turn around and refer you to some other brokerage firm. So to close that question, what you're putting in the additional provisions, I think would need to meet kind of the litany of things that we just discussed, and it would be not just as simple as reinserting 5.3, certainly.
Yeah. So, but again, guys, I want to point out, I mean, this is not passed yet. I mean, the position statements are passed, so that they are what they are, unless they decide, and they could unilaterally decide to update them too if they pass the rules and decide that maybe this wasn't what they were going for. I guess they could do that, but the rule is still a proposed rule, so it's not. Hopefully somebody looks at this and kind of figures out what they're going to do, but I do think we're going to get something in the realm of informed consent that you guys are going to have to do in order to share that information. There's going to be something there. It's just a question of what it looks like and whether hopefully maybe they fix this, but that's my 2 cents. Do you want to, I don't know. Have we spent enough time on this? Do you want to spend more time?
Yeah, we're 45 minutes in. Is there any way we could make a shift over to contracts? And then if we have time, then we can kind of jump back to this and try to address some questions. Would that work?
Well, I think the contracts is easy. And the only reason I say that is because there are substantial changes, but a lot of them are based on changes from the statutes that were updated through this legislative session, like for good funds and metro districts and some other things. The big change is this 5.3, and that's really, I would, if you're not going to take a red line class, then you can either go take the and it's not Car that has the free class, it's Dora that has the free class that you can go through, and they'll go through all the changes that were made if you're just looking for that kind of thing. I think it's probably worth taking a red line class on some of this stuff because you get a little bit more flavor for what you're going to have to do. So, but anyways,
What,
that's
as opposed to maybe shifting topics, do we want to try and knock out some of these questions if we can, or do we? I mean,
yeah,
I'm
that might make sense. I see do you want to go through the questions, honey, or do you want?
Let's see. Should I just kind of start at the top and roll through here?
yeah, sure.
Okay. So Cindy, hi Cindy. Many states are now allowing agents to put TBD in the buyer agent compensation in the listing agreement. Do you see us heading that direction?
I'm not sure how they're pulling that off with the NAR settlement. Are you, Scott?
Yeah, I mean, in a buyer, you're talking about in the commission section of the buyer listing agreement. Yeah, I mean,
I assume
what
so.
what your MLS rules require universally is I'm trying to think of the term. The amount needs to be objectively ascertainable, is the language that the MLSs use in their rules. And so objectively ascertainable certainly is not TBD. That there's and that includes, specifically not ranges, not TBD. So I'm not sure who's giving that advice, but I would definitely, check with your MLS before you are taking that advice, because I'm not familiar with any MLS rules that would allow for that, not just in Colorado, in the United States. And we've got, I think, 13 or 14 different MLSs in the state. So you might check with your MLS before you do that. That's ultimately the rule that you would be violating for doing that. This is not has nothing to do with the Division of Real Estate, only MLS rule.
Okay. How does this affect REAPs? REAPS.
Oh, I forgot that acronym.
I forgot it too.
Real Estate Administrative Professionals.
Yes.
I mean, that would be if they're not. That's actually an interesting question. I mean, I guess they can't be a designated broker. They would have to have have to have some other language that would essentially authorize because they're a third party, right?
Yeah, I think we've often told people to put language in their listing contracts authorizing that they receive confidential information or that they may receive confidential information. What's interesting about that, though, is that probably has to be updated to accommodate for whatever this informed consent standard is going to be.
Yeah, I don't. That's a very good question. I hadn't even considered the implications of all of this on them as a third party. I mean, it's and I guess going that direction for somebody who's working underneath a broker associate, I don't know. I'm less agitated by it than the concept that somebody who's working under a brokerage firm, or somebody who owns a brokerage firm, or is the employing broker of a brokerage firm, isn't allowed to receive that information, unless there's this, very clear informed consent. That's the part that gets me. So I would say for a REAP, it's going to have to be the same thing, and you would want to identify that you're sharing that information, or that the consumer's authorizing you to share that information.
Yeah, I think the informed consent, whatever language is put in there for the employing broker to receive it, will have to be put in there in order for REAPs to receive it. You're going to have similar language and advise of the risk and all that other stuff. I mean, TCs. I hadn't thought of that. You're right.
Good, reasonable question. Somebody should probably be asking that. And as Damian mentioned, there's going to be a stakeholder meeting on November 19th, and you should have received. Now, maybe you didn't get just yet. Maybe I got it a little early, but you should have received be receiving, if you're a realtor, a notification from CAR at some point today. So, and just while I'm talking, I'm going to add, and we're not going to have time to get to this, but just for other informational purposes for you guys, I want to share the sunset report that was presented. It was presented on October 15th. So, and I just put it in the chat. I think it popped up. Oh, it goes to host. No, it only goes to hosts and panelists. So I'm not sure why. Oh, maybe I can
here.
that.
You might do the little drop down and then you can change it to everyone.
This Zoom stuff is brand new to me. I'm still just getting things figured out.
Just kind of getting figured out.
Yeah, just learning here. I feel like my father. Um, Anyhow, I put the report in there. It's a long report, but there's, I think, 8 or 9 recommendations, maybe 10 recommendations. I haven't opened it in a little bit, but I'd encourage you guys to download that and give that a review too. I won't get into the details of that because that's a whole separate discussion. But essentially, that report is going to the Colorado legislature, and the recommendations contained therein are coming from the policy analyst at COPR, which is the agency that reviews all of the divisions and boards and commissions in the state. It's a statutorily mandated thing. And so they spend a lot of time preparing that report, spend a lot of time kind of embedded in each of the divisions, including the division of real estate. And that's the end product that they produce. They'll present that to the legislature in the next legislative session, so starting sometime in January. And then the legislature might be making, based on those recommendations, changes to the license law and or the division, commission, et cetera, based on the recommendations that are contained therein. So just so everybody has it, again, we could spend, half a day probably going through that. I know we don't have time, but I just wanted to do that while I was thinking about it. And Jill, you want to try and knock out a few more questions or?
Sure.
Scott, I think we should probably talk about a couple of them that maybe, well, let's knock out questions and we'll get back to that.
Okay.
Okay, can a brokerage have an office policy that all broker associates must have the managing broker listed as a co-listing agent?
Sure. Absolutely. I mean, that would just be that they'd be a designated broker on every single file. They would force consent. They would take consent that way.
We're going to take consent. No, we don't need written informed consent that's voluntary. We're just going to take it.
Okay, so with today's rule, are we allowed to double end still with 2 brokers in the same firm?
Yes.
Yes. You just have to disclose that you're in the same firm. And it's a new disclosure requirement that's going to come up. And it's so funny because Commission Position 22, if you look at the red line of it, it literally had in there that was not required to be disclosed. And now they've changed it to it must be disclosed. It's a complete reversal of what the policy was when Commission Position 22 came into existence, I think in 2020.
And it says that disclosure is that you have to make a disclosure that it is a conflict of interest.
Yeah.
Which I'm not sure that it is. I mean, I've never even really thought of it, but I mean, there's a potential for a conflict of interest. I mean, I suppose when you get into the supervision issues and everything else, but to say that it is a conflict of interest, that's very different than saying a potential conflict of interest.
Yeah, and that's exactly what it says. Here, I'll share again just so everybody has the rule. But I mean, that's literally what it says, is that it says if they do this, then the designator must disclose this as a conflict of interest.
Yeah,
which
and
is
I don't think it is.
And it's so funny because they've gone so far to protect confidential information and say there's no way we're going to let the employing broker get that information unless they get a voluntary written consent. But this is a conflict of interest. So if you see, it's odd.
I mean, it almost harkens back to the concept of dual agency, which it was terrible. But in lieu of that, we pivoted however many years ago to designated brokerage. And it's never been a conflict of interest. In other words, if it had always just been by default a conflict of interest, I don't know how it could have ever been justified in statute.
Yeah.
So
maybe they'll change that. They might update that one too. Who knows?
I don't disagree that it's a potential conflict of interest, but I don't. I guess, and I haven't given much thought to this until just as I'm flapping my gums. But potential would be one thing. There is a potential.
Even potential, it seems like a stretch. If you're not, I don't know. It just seems like if one client is going to their one broker is going to their employing broker for advice because they got informed consent and the other one didn't, how is that a potential conflict of interest? The employing broker is not getting it for both sides. So
yeah, I don't know, but more questions.
Yeah, there's piles of questions. So do you want to keep rolling through those or do you want to touch on contracts or what do you want to do?
Well, I think if we've touched on them, I'm going to try and, I mean, there's not, like I said, there's just not a lot to talk about in contracts. So, but I think let's go through the questions, roll through them, and I'm just going to try and get rid of some that I
think that
figure
we've already
we've probably
covered. Okay.
covered or touched on.
Okay, what about any of our additional folks who would have access to the file or info, for example, transaction brokers or marketing people who are looking at the contract to know what to use for marketing?
Same answer. I mean, I think it's literally the same answer. And that's the other thing about whatever informed consent you're giving. It would be, that would, I guess, would fall under specific. And it would so it would be specifically describe the confidential information that could be shared. And I think it would also have to specifically describe who that information can be shared with. Again, I think it applies to everybody. We're focused. I think, and admittedly, I've been so focused on employing and supervising brokers because to me, there's just such a like gobsmacked irony about the employing and supervising brokers. But the same standard would apply to REIPs, to anybody else anybody who's getting a copy of that contract. If it includes confidential information, there would need to be informed consent in order for them to receive it, unless the client specifically consents to it. Do you disagree, Damian?
No, I don't disagree at all. I think that this
I just
has
haven't given much
far-reaching-
thought. I just haven't given much thought to the others. I mean, the others I have so much less of a problem with on some level. It's the supervising and employing brokers, and really it's both. But the irony of that, an employing broker who is literally the party to on behalf of the brokerage firm the contract isn't able to receive that is the one I can't wrap my tiny little brain around.
A few people are asking about title and what that looks like for title.
Ooh, that's an interesting
Yeah.
question.
Same answer.
I
I
mean,
think.
you guys don't usually get copies of listing contracts, though.
Not usually, but we're getting copies of obviously purchase contracts.
And I think maybe some title companies ask for commission purposes might ask for a copy of a listing contract.
I mean, in most cases, listing contracts aren't going to have a ton of confidential information in them. I mean, where it comes up is when the seller's in foreclosure and you have something in there in foreclosure, or you have price reductions, or something about those motivating factors. And I think that's why the position statement probably says to advise your brokers not to put confidential information in the listing contracts. It's kind of weird when you want it to be a contractual term. Why wouldn't you put it in the listing contract? But I don't know as title companies are going to be impacted by this as much. I do think all the TCs and everything else, but I also know that, at least I was advising, I don't know if everybody else was, but when you have TCs, you should have been having that consent in your listing contract anyways. You should have been having some kind of paragraph that says that you're providing this information to some third party, because that was required under the old rules. I mean, because there was nothing in the listing contract gave permission to give that information to TCs. The only ones that had permission under 5.3 were employing or supervising brokers. So to some degree, the TC hasn't really changed much. You still need that consent. It's just what that consent looks like might be different depending on what version of 6.27 passes.
Yeah, all true. Great question. I mean, it's just stuff that we haven't been really focused on and thinking about this, and there's open questions about all directions. But the only answer I could possibly think making sense based on how everything's drafted currently is that the same standard would apply regardless of whether it's an employing broker or a TC or a title company or a marketing person or whoever might be. Compliance officer within a brokerage firm who might be receiving stuff, all of it.
Yeah, whoever's getting this information here in the statutes, and I'm just showing 1210-4042, if you're going to share any of that, then you're going to have to get whatever this informed consent is going to look like out of 6.27.
And you'd need to identify, I think that's under the specific piece, specifically what you're authorized to share and who you're authorized to share it with, including any of those other folks that may, ultimately get their hands on it.
Guys, is there any chance that this is not going to move forward? Someone made the comment like, why are we even doing a webinar on this if this isn't implemented or approved? Can you just kind of talk about this conversation and why it's important?
Yeah, this is going to something's going to get approved. I can tell you guys that now, because up until October 7th, I think there was a lot of us that were hoping that that there was going to be a pivot, or there was going to be a change, and that something different was going to come out of the commission to that wasn't going to be quite as difficult as this is, or complicated as this is. I guess I use that word. But after the October 7th hearing, what came out of that was, number one, they removed 5.3 from the listing contracts, which means that that is gone no matter what. So we have to have something to replace it one way or the other. Number two, the commission position statements were actually passed, which means that that is now guidance that is part of the position statements of how you're supposed to be handling confidential information. And number three, these rules were proposed and they have been noticed and they are going to be looked at in December. So don't think that something's not going to pass and we're going to go back to business as usual. There will be something that passes out of this. I'm just saying that I think it's still open for it to change based on the fact that there's still stakeholder input on November 19th and there's still a public hearing on December 2nd in which there can be comments from the industry and stakeholders to maybe help shape that policy. It's just a question of how much they can shape it from what's been proposed.
Yeah, but I mean, to Damian's point, 5.3 is gone. Those forms have been approved. Red lines have been issued. The effective January 1st, 2026, there will no longer be any consent authorized through the listing agreements. And in the absence of that, there will need to be some form of consent. And I don't see how this is going to change all that much. It may get cleaned up or clarified a little bit. Maybe there'll be a decision to promulgate an additional form to take care of that. But yeah, I don't think I don't think there's any chance that things, stay as they are, so to speak.
And if brokers don't love what they're hearing about these proposed changes, what should they do?
Well, the division has sent out, I think, at least one, maybe two notices related to the November 19th meeting that they're having, and the intent of that is to receive and collect stakeholder feedback, which everybody on this call, brokers or not, would be considered stakeholders, and they're going to have an opportunity to participate in that. There's also a link on their website to submit any written comments to the extent you want to do that if you're not wanting to show up and have a discussion or listen to the discussion and potentially participate in that. There will be the hearing itself on December 2nd, and there will be public comment related to that, live, to the commissioners in anticipation. So there's some of those opportunities to participate to the extent that you are interested in voicing your support or concerns or whatever you might have related to any of this.
Very good. We're over our hour. Do you guys have time for a few more questions or do we need to wrap things up?
I'm good for a couple minutes if we can, if we're not dropping anybody off.
Okay.
There's a couple of other rules on here that we haven't even really addressed. The veteran license portability, there's not much to talk about. I think, what was the other one that had some?
I think we should talk about, the big one I think is that the annual commission update course.
Oh, yeah.
So I'm trying to find it, so there's a bunch of things for continuing education providers that'll have to deal with it. It has made compliance for continuing education providers is going to be a lot more difficult. There's going to be a lot more scrutiny on students and paying attention. I could show you some of these rules here somewhere that if I could find them, but of course I can't.
While you're looking, I'll just say that the rule that they're proposing, and honestly, this was one of the recommendations that we had made to the policy analyst that beginning, I think it's beginning next year. This is something we maybe need to double check, but beginning next year, the 4-hour annual commission update course that has historically been available January 1st through December 31st of that year. Now, there you go, must be completed not later than July 1st of the calendar year. So you basically got to take that 4-hour update course in the first 6 months of the year and get it done, which I'm honestly supportive of. People I've jokingly told people that some licensees will get their New Year's Eve back now because they're not trying to slam that 4-hour course in between 8 p.m. and midnight on December 31st, which is useless at that point, in my view. And so I think this is a good change and supportive of it. People ought to be able to commit 4 hours of their life in the first half of the year to take the annual update.
Yeah, the one thing I'm concerned about this rule change is that I think what they should have done is they should have made it effective January 1st of 2027. This looks like it's going to be effective January 1st of 2026. And I think what we're going to end up with is a whole lot of brokers that don't read a newsletter or don't hear about the change are quite possibly going to end up defunct or in default, and there's no way that they can correct that action other than taking 24-hour reactivation course. So I think the implementation of this, I mean, the concept I think is great. I do like it myself. I think the implementation is a little faulty in the fact that it probably should have been pushed out to say, hey, let's give them a year. Let's use the 2026 annual commission update course that everybody has to take to inform everybody starting January 1st of 2027. They're going to have it done in July. But I don't see anything that does that for them. So if that passes in the format it's in, I think we're going to see a whole lot of brokers that are non-compliant because they didn't realize they couldn't just take it December 31st again.
They could take the 24-hour activation course or reactivation course, or they could pass the state portion of the licensing exam. Isn't that the other option?
Yeah, the state portion of it, or taking 72 hours of pre-licensing. Yeah,
that's the other one. 72 hours of pre-licensing. None of those sound like great options, but yeah, that's another change. And again, I honestly kind of am supportive of, but don't disagree that there'll be some confusion in the second half of next year by a whole bunch of people, probably not like anybody that's still hanging around on this phone call who actually pays attention to stuff. But there are an awful lot of people. I know you won't believe it, but there's a number of out of the 40,000-ish active licensees out there that aren't as diligent as the 267 people that remain on this phone call after an hour and 8 minutes of having to look at Damian. Again, they're just here to look at Jill, though. I think that's what's.
Well, this is the one I get a kick out of those. Look at this. All of these kind of say the same thing, but it says course providers must implement and maintain a reliable method for monitoring live student attendance throughout the full duration of each approved continuing education course. Student participation, including start and end times, break periods, and any observable inattentiveness must be tracked to ensure the students are continuously present and engaged for the entirety of the instructional time. I'm kind of curious as to how I'm going to do that, but there you go.
Lord.
Keep your eyes on the screen.
Yeah, right. Nobody look away because I might say you're inattentive.
I think in your classes, Damian, they'll just paint eyeballs on their eyelids.
We're going to get some Chicago Title glasses that have eyeballs on them so you can just sit back.
You're not going to facilitate the breaking of commission rule, Jill.
Oh yeah, probably
Chicago
not.
Title would never do that. That's not. No, but that is it does seem like there's definitely some more accountability. And listen, I'm with the explosion of kind of Zoom education and online stuff. I mean, it wasn't many years ago that everybody, if they wanted CE hours, they were having to trudge down to the Realtor Association or to some classroom or whatever and sit there. So I do there should be some accountability in terms of people paying attention. So
there's nobody that slept in class when they were live. That never happened. There weren't people that came back late from bathroom breaks. There weren't people that went out and took phone calls. That never happened in live classes.
I'm not saying that it doesn't happen. I'm just saying that we've got it easy now with some of the Zoom stuff, and I just as a matter of concession would say that some of this stuff, some of the rules. I mean, we spent a lot of time talking about 6.27 and the kind of illogical nature in some ways of that and the position statement and everything else, but. I'm all for supporting, increasing or raising the bar in terms of expectations with things like this and getting the CE done early and so forth. So I don't want to just be completely negative. That's what I'm trying to get at.
No, I think there's some stuff in here that makes some sense.
Right. And in the forms, I'll also say with relation to the forms changes, as you guys go through, the red lines and or take red line classes, I think there's, there is a genuine attempt by the Division of Real Estate in their forms modification to try and make things more, consumer friendly or, maybe more digestible. And in all honesty, there's a big push among some people. The settlement that was approved by the court has been appealed by about 8 different parties. And one of the common threads among all of those appellants who are appealing the approval of the NAR settlement is that a couple of things. One is, and I agree with this one, the lawyers made too much damn money. there is no question that that was the case. And that's one of the things that they're pushing back on, saying the settlement shouldn't have been approved because the lawyers made out like bandits. And lawyers are terrible people and they don't deserve to make out like bandits. The other thing, that real common thread that's part of those multiple appeals of the settlement agreement is that, there's some buyers have been, harmed in some ways by this. And that what's really been shed light on is that some of these agreements, now we have agreements that are promulgated by the Division of Real Estate in Colorado and have for whatever, 50-ish years. And that's a consumer protection agency. And I think our agreements are outstanding in the state of Colorado. And they're really, from colleagues around the country, referred to as kind of they're held in very high regard because throughout most of the country, they're drafted by sometimes even local realtor associations or the state association. There hasn't been the same kind of collaborative process under the guise of a consumer protection agency. And so that's very good. But these appellants are really targeting some of these agreements around the country, basically saying, well, they're written on behalf of realtors or on behalf of licensees, and they disregard consumers' rights. And I don't think that's ever been the case in our forms whatsoever because of how they've been promulgated. But the appellants are really shining light on some of those forms around the country that they're not easily digestible by buyers, and they're one of the most vocal appellants of the settlement. She's basically been saying, these should be written for my 80-some-year-old, parents, and they ought to be able to understand them. And so I'm not disagreeing with that premise, but again, I think our forms have been very well drafted historically. But I do think the Division of Real Estate is taking steps to, not necessarily write them for 80-year-olds, but to make them more easily digestible by consumers. And so, it's
and I think that statement's a little unfair too, because if you go through our whole world, I don't see people worried about Apple and Google's terms of services being dumbed down so that we make sure that they're understandable for the average consumer. I don't see depository agreements for the banks being dumbed down, or the credit card companies, or there's so many agreements that you deal with every day. And somehow ours got targeted as they're just too difficult for people to understand, while ones that I think have even larger impact on people have stuff that are all over.
No question. The reality is, I've said to our members or to, realtors and our members for the last several years, is the industry has been under a very specific assault from a variety of folks, largely, attorneys, and these antitrust lawsuits are reflective of that, and the Department of Justice. And it's really sort of increased the scrutiny on our stuff, including, our agreements across the board. And so but I agree with you 100%. How many times a day do you click on some accept terms of service box and you don't even have to scroll through it, right? And it's got all kinds of stuff in there that, somebody's 80-year-old parents wouldn't understand. I wouldn't understand. That's why I partnered up with Damian, because he's a smart lawyer. I just have to rely on him, I think. That's a joke.
Oh, that's pretty sad.
I know. All right. Well, I don't know if we got through any more questions or we made any more accomplished value for anybody, but I think we did, maybe, hopefully.
I think this was great. Thank you guys so much for your time and your insight. Big changes sounds like around the corner. Hopefully we can affect some change with what they're talking about. So I'll send up tons of follow-up information to everybody. Stay tuned next day or two. I'll get everything gathered and I'll push that out to everybody who registered. So thank you for being on. We hope you enjoyed this, and stay tuned for additional information.
Thanks, Jill. Thanks, guys. Thanks, Chicago.
Bye. Thank you.
Thank
Bye,
you,
guys.
Damian. Thank you, Scott. See you guys soon.
All right. Bye.